Please be seated. We're ready for argument in 230662, Raoger Corporation versus Myers.
May it please the court, Mr. Knight will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court, Steve Knight on behalf of the petitioner, Cadeau Restaurant. The issue in this dram shop case is whether a seller of alcohol is entitled to summary judgment when there is no evidence that the patron appeared obviously intoxicated to the point of being a danger to himself and others, and every witness knowledgeable about how the patron appeared, both at the restaurant and after the restaurant, confirmed that he looked and acted normal. Under a proper application of the Dram Shop Act, the seller of alcohol is entitled to summary judgment in this context, and because the Court of Appeals erroneously decided otherwise, this court should reverse and render. Under the Dram Shop Act, sellers of alcoholic beverages are not liable for harm caused by a patron unless the plaintiff meets what this court has called an onerous burden of proof. The plaintiff must prove that at the time the provision occurred, it was apparent to the provider that the patron was obviously intoxicated to the extent that he presented a clear danger to himself and others. In this case, there is no evidence that Khan, the patron, appeared obviously intoxicated at Cadeau, and every witness who was knowledgeable about how this gentleman appeared confirmed that he looked and acted normal.
Was there any testimony in the record or any evidence in the record about whether or not drinking occurred at the home that they went to after they left the restaurant? Because my understanding of the record is that the tab was closed at about 10:30 p.m. and that he left that home after midnight. So it seems to me that that's kind of a gap there that should have been investigated as to whether drinking was going on at that home.
So you're right. The evidence that's in the summary judgment record is that Khan testified that the only place that he consumed liquor was at the restaurant. However, he also inconsistently testified that they arrived at 10 o'clock and would have left 2 hours later. Well, 2 hours later is midnight, and he further testified that Jones's house, where he went before the accident, was 10 minutes away. He testified he went inside for a period. He testified that the accident occurred about 10 minutes away from her house. So his 2 hour window makes no sense. What does make more sense, though, is that he testified, and what the record shows, is that he opened his tab at around 10. He closed his tab at 10:30. The tab reflects the precise number of drinks that he says he purchased from Cadeau. 3 drinks on which he and his dinner date, Jones, sipped as they waited for their dinner to be ready to take. So he testified that he would have left the restaurant between 5 minutes and 30 minutes after closing his tab. Well, given the benefit of 30 minutes, he would have left at 11 o'clock p.m., a full hour, over an hour, before this accident occurred. But what's clear is Khan was clear under oath that I only purchased the 3 drinks that are actually reflected on his tab. That's the only evidence of the number of drinks this restaurant provided him.
If the restaurant tab reflected 11 to 17 drinks that the expert said that he thought had to have been consumed, would your position be different in terms of whether it would be apparent to the server that a person was obviously intoxicated?
So a couple of things there is their expert talks about some crazy number of drinks, like 9 drinks, but he does not say, nor can he say, that that is reflected on any record of the restaurant.
Right, but I'm just asking, at some point, isn't purely, serving and seeing a patron consume an inordinate amount of alcohol, is that enough then to make it apparent to anyone, including a server,
So I was
that the person who's consuming those drinks is obviously intoxicated.
I was anticipating a question like that, and I would say that the answer is clearly that is not sufficient under this act. Why is it insufficient? Why is it insufficient under the act? Because the Texas legislature based liability solely and exclusively on how the patron appeared at the time of service. If he purchased a large quantity of liquor and did not appear obviously intoxicated to the extent of being a clear danger to himself and others.
Well, it says apparent to the provider.
Right.
Well, I know that Khan was a big boy, but if the provider gave him 19 drinks, as the expert testified, he doesn't need to have a lampshade on his head to Justice Bland's question to have for it to have been apparent that he was obviously intoxicated. 19 drinks is a lot of drinks.
So we have to be very clear about what's in the record. Their expert did not say.
Oh, no, I know. That's why Justice Bland was asking you a hypothetical question. But the hypothetical is, if the Cadeau server, if the tab reflected 19 drinks, and they served 19 drinks, and Khan was able to hold it together, would it nevertheless, could you still satisfy Section 2.02B1 of the Texas Alcoholic Beverage Code?
If by he was able to hold it together, you mean he was not displaying any obvious signs of intoxication to the extent of being a clear danger to himself and others, which is what I'm gathering you're saying, then the answer is the restaurant is not liable. That is the sole textual benchmark for liability. The legislature could have made the test. How many drinks did he consume? What was his blood alcohol level at the time that he was at the restaurant? The legislature didn't impose liability based on any of those things. And I submit that there's a good reason for that, as this court has explained in the Graff v. Beard case and also in the El Chico case. This court has made observations that people that test over the legal limit, most of them don't appear obviously intoxicated to the point of being a danger to themselves and others. And the court has equally, in several decisions, recognized that how and when alcohol actually penetrates one's system to cause them to act a certain way varies by individual. It varies by alcohol tolerance. So if somebody like Khan, a large man, consumed 19 drinks, which given the time that he was at the restaurant is, I'd submit, impossible, number one. And number two, the expert, their expert, did not say that the restaurant sold him or supplied him with that inordinate amount of drinks. It would be their burden to prove otherwise, that these drinks were provided by the restaurant. All that they say is that he would have consumed somewhere between 9 and 19. There's no evidence that my client would have provided all those, but even if they did, maybe this man is somebody that can consume 9 drinks, leave the restaurant, and those drinks don't manifest any signs of intoxication or anything else until half an hour later. We don't know. But what we do know is that the statute says we're only liable if, at the time that we provide the alcohol, how did this man look? What was his appearance when we provided it?
Well, he did testify about that, and he said he was overserved and that the bartender should have observed his intoxication while he was at the restaurant. So why isn't that enough to create a fact issue?
Well, because, Judge, what he actually testified to, and this is clear in the record, is that he felt nothing from the alcohol. The alcohol had no effect on him.
So he said that at one point, but didn't he also say that the bartender should have observed his intoxication while he was at the restaurant?
And that's what the Court of Appeals cited. But
well, is that true or not? Did he say that?
He made the comment that, yes, I think the bartender should have observed that I was intoxicated, meaning over the legal limit. But that is no evidence to meet the statute's standard, because the standard asks, what signs of intoxication? What is it that we were supposed to observe? And Khan, on that point, was absolutely clear. He testified that the alcohol had no effect on him.
Well, then, so those two statements seem to contradict each other.
I don't think they do, because
well, if you observe something, it's something you can see.
Well, yeah, but you can't see, okay, if anybody in this court right now is sitting in the audience and they have overconsumed, they are legally intoxicated, How can you say that by looking at them, everybody looks perfectly normal? How can you say that they appear obviously intoxicated? So what I'm getting at is Khan's statement is not a statement about how he appeared, any outward manifestation of drunken conduct. To say that I think somebody
I
should
just don't
have,
see how you can read it that way if he says the bartender should have observed.
that he was intoxicated. That testimony might go somewhere if he says the bartender should have observed my intoxicated behavior. Me walking in a staggered manner, slurring my speech, bloodshot eyes, any of that. But Khan testified that he exhibited none of those signs, nothing.
So how could a bartender observe intoxication but for the patron's behavior?
They can't, which is what makes Khan's statement absurd.
Contradictory, right, that's the
Whether
whole
you
point.
want to say contradictory or just nonsensical, what the statute requires is at the time of service, it
Was
was,
he basing that testimony on the evidence of his blood alcohol content 3 hours later?
I think that it came out that he indeed was intoxicated, and he was asked a question, should the restaurant have seen that you were intoxicated? He says yes, but when he's asked, okay, well, what signs would they have seen? He says there weren't any.
So do we need to conclude that either, not just we, is it true to say that either the blood alcohol test was wrong somehow, or Khan's wrong when he says he had 3 drinks and didn't drink anywhere else but at that restaurant? Do we have to conclude that one of those is wrong?
I mean, I think that you can conclude that there are clearly inconsistencies in the record, but what is absolutely clear from this record is that everybody who saw this man at the restaurant testified that he exhibited no signs of drunkenness, zero. And what's more is, even after the accident happened and Officer Williams came to the accident scene, Officer Williams testified repeatedly, I could not tell by this man's appearance that he was intoxicated at all. None of my colleagues could tell.
The sergeant could tell.
No, his sergeant could not tell that he was intoxicated. His sergeant could only tell that I detected a smell of alcohol, which, as Officer Williams correctly testified to, only means he may have had a
It
beer
wasn't
that night.
enough because they had to use the HGN test.
Yeah, so.
Could I come back to Justice Bland's question, though? And I want to start it again with the caveat that this is a hypothetical. Suppose that the Cadeau bartender lined up 100 shots of tequila or some other bad idea, lined them all up, and watched Khan drink every single one of them, and then served him 101st, or if it's not 100, 1,000, or 1,000,000. Why isn't that enough to, within the meaning of the statute, make it apparent to the provider that the individual was obviously intoxicated to the extent that he presented a clear danger to himself and others? Is there no number that would fall within that statutory text?
So what you're.
And he lines them all up and does all of them, and then sits there calmly, does nothing, and then says, I'll have one more for the road, and it's the 101st or the 1,000th or the 1,000,000st. Is there no number where the sheer quantity of alcohol that the provider provides is enough to make it apparent?
So even as Myers concedes in their briefs on the merits, what this concept of apparent intoxication to the extent of being a clear danger to himself and others, he concedes that this means that there must be intoxicated behavior to observe. So the answer to your question, and yes, it seems absurd, I suppose, but the answer to the question is the way the legislature wrote the statute, basing it on what conduct was apparent in terms of drunken conduct, slurring speech, stumbling, mumbling, all this sort of thing. If somebody quickly did a lot of shots, but they are not exhibiting any signs, then the answer is the bar is not liable. And if that is somehow not a satisfactory answer, the legislature, it's the job of the legislature to change it. Like I said before.
Well, there's nothing in the text that says behavior. It just says obviously intoxicated. And I think what Justice Sullivan's asking is, at what point does it become obvious just from the number of drinks that you're selling somebody that they're intoxicated?
And I would say once it sets in that this person is now the effects of the alcohol, which are delayed in some people and not in others, tolerance, body size, all that sort of thing. Once the
So
alcohol.
the answer is never. Just from the number of drinks alone, it's never going to be obvious.
I should think that
Not if it-
ordering a 101st tequila shot is pretty much always a bad idea.
I think it would be obvious at that point because this person would be dead. But again, that would be the manifestation of the alcohol. If it's a different example where somebody lines up 6 shots, that's a lot of shots. Or 9 shots, that's a lot of shots. But if somebody can easily tolerate that much liquor and is exhibiting no signs, which on this record here, the 3 or 4 drinks or 9 that they say, even though they have no evidence that we provided 9 drinks, there is no evidence at all in this record that Khan appeared intoxicated at the restaurant. He didn't appear intoxicated at the scene of the accident. And the only way Officer Williams was able to find out what eluded everybody about Khan that night was by doing this specialized HDN test on his pupils, which no restaurant
Mr.
could
Knight,
ever.
your time has expired.
Okay, thank you.
Thank you. We'll hear from the respondent.
May it please the court, Mr. Kita will present argument for the respondent.
Good morning, Mr. Chief Justice. Your Honors, may it please the court. The problem with my friend's argument is that he ignores the obvious fact that something can be apparent and also be ignored. The quality that somebody exhibits when they've had too much alcohol can be apparent to everyone. And the question of whether it's apparent is an objective standard. This statute has always been interpreted that way. But something can be apparent and be completely ignored by the person that's supposed to be watching it. Similarly, a person who is trained by the Texas Alcoholic Beverage Commission and admits to receiving such training and admits to knowing what the standard is and what someone will look like if they consume that much alcohol and what percentages of blood alcohol concentration mean or what effect they have on someone's behavior can be completely correct in their acknowledgement of that standard and also be lying about what they saw when they served the drink.
Is it at least subjective, though, in the sense that the apparent requirement? Would it have to be subjective in the sense that there has to be an employee of the bar who's in a position to see the intoxication?
Yes, Your Honor, because of course this statute only applies when you're seeking liability against the bar itself. So when they passed the statute, they did not want to use a common law negligence statute that they were afraid that, they did not want to use the common law rule that they anticipated this court would create, which would just simply have a general knew or should have known standard, which may, under some common law principles, for example, if we're dealing with premises liability negligence, would imply a duty to investigate, a duty to make an inquiry as to how much someone's had to drink. The legislature said it has to be apparent that they're in clear danger of themselves or others. But nowhere did it say, and this language was omitted from the bill, that it had to be knowingly or intentional, or that you had to show the subjective knowledge of the actual bartender or server or servers that were providing alcohol at the time.
Well, could you give your take then on what the words "to the provider," what work do they do in the statute?
Your Honor, I think that those words would be important in a case, not on these facts, but in a case where, for example, suppose someone came into a restaurant, sat with their friends in the corner, and never actually engaged with a bartender or a waitress. Perhaps their friend bought a bucket of beers and brought them back, and they simply never interacted, and there was no evidence that it was ever apparent to the provider. Here, there's no question that Jennifer Hottie served Mr. Khan. She admits that. And although she does not admit that she served him more than 4 drinks, she acknowledges maybe there could have been 2 tabs. She says, I wasn't watching him the entire time. Mr. Khan admits, as Your Honors noted, that he admits that I might have been intoxicated. The idea that on a summary judgment record, all of this evidence, from where you have the admission that he is going to this bar on an empty stomach, that he didn't have alcohol anywhere else, that he only consumed alcohol in that 1 hour-and-a-half period, beginning at 9 p.m., this accident was at midnight, and it's obvious he didn't have any alcohol between the time he was arrested and the time his blood was taken. There is no other case that this court or any lower court has ever addressed that had facts like these. The only thing that this case is missing, that the other cases don't have, is the expert saying, this is what I calculated his blood alcohol concentration to be, this is how retrograde extrapolation works, and he would have been looking like this at the bar if he had 19 drinks.
Was he asked if he had consumed alcohol at the home where he took the woman?
Your Honor, if he was, that part is not in the summary judgment record. What we only have is the expert's declaration where he computed the amount of drinks that, it was undisputed, were drank in that hour-and-a-half window that he was at the bar.
No,
But
they
we
wouldn't
have
know that. The blood alcohol level was taken at the hospital. And of course, they don't know what happened between the restaurant and what happened when they were at the home. Did they order dinner to be eaten at the home?
I believe in the record, Your Honor, it says they had the dinner to go. But again, we're at the summary judgment level. This does seem a little fishy.
I mean, it seems very unusual to me that somebody would go to a restaurant, order dinner to go to be eaten at the home, consume alcohol there, and then when you get to the home, just quit drinking, period. That seems very unusual to
It
me.
does seem unusual, but again, this isn't an appeal from a jury trial. This is, we look at all the evidence in the record and take the parts of it that are most favorable to the non-moving party. So this this defendant has admitted, and again, as a quick aside, although we're dealing with an appeal from the severed action, he was a defendant, Mr. Kahn was a defendant in the underlying trial.
Self-serving that he would say that they shouldn't have served him, I mean.
It was similarly self-serving that Jennifer Hoddy would say that I only served him 4 drinks. The idea that we would pick and choose the parts of the testimony.
There is a bar tab. We're not relying on her naked statement as to how many drinks she served. There's a tab.
Yes, there is a tab.
And no evidence that he obtained free drinks or drinks on the side or anything like that.
The evidence that he obtained additional drinks is the fact that it's impossible for him to have only had 4 drinks in that window and have a blood alcohol content at 0.13 at 3 o'clock in the morning.
So the blood alcohol content, that is the strongest piece of evidence, obviously, of his intoxication. And that's used all the time on the criminal side to extrapolate back to the law enforcement encounter or the accident to show intoxication at the time. But given that this is not putting criminal liability on the offender, the person who consumed the drinks, but on a third party, is that evidence alone sufficient to demonstrate awareness by a third party so that it was apparent to the third party that there was intoxication at the time that the alcohol was served?
Well, yeah, I would have to think that the answer would have to be yes, because on the criminal context, we're talking about stop for a second. I am certain that it's not uncommon for a person arrested for DWI to say that they had 2 beers, okay, when their blood alcohol content is far above that. Okay? And the only testimony that's in the record at a criminal trial is the person saying, I had 2 beers, and a bartender perhaps saying, I don't remember over-serving him. But we allow the use of retrograde extrapolation and a blood alcohol content to take his liberty away and put him in jail.
Right, but so here, you're saying that that evidence should be treated the same in connection with a dram shop case. Are you saying that every provider of alcohol is strictly liable anytime a defendant is over the alcohol limit?
Absolutely
Because
not.
that seems very different than what the statute says.
Correct, and that's not the rule we're asking for. This has nothing to do with strict liability.
What is the rule then?
The rule, well, the holding in this case should be on these facts, it was sufficient to survive summary judgment. The holding that transfers to other cases should be that when a TABC licensed bartender is aware and acknowledges that she is aware of what the standard is, and when given the information of what this person's blood alcohol content was, admits that if he was at that level, he would have been showing these signs. That is sufficient evidence to cross the bar to
Is it fair to say that either one of 3 realities exists under this record? One is the BAC test was wrong somehow, or the restaurant served him more than he and the tab and the bartender are saying they served him, or he drank between the restaurant and the accident.
And that seems to be the case.
One of those three has to be true, right? Are they equal inferences?
I wouldn't say they're equal inferences, Your Honor, because...
Why not?
Well, because the evidence that we have on this record, right? So we have no evidence that he was drinking somewhere else. And at least,
Well, no,
okay,
we have him saying, I only drank at the restaurant.
correct. But we have at this procedural posture, we have to look at all three of those options that you just gave in the light most favorable to my client. This is not, for example, like a medical malpractice case where you have an expert saying, well, it's possible this chemical could have caused this negative outcome without explaining anything in between. And there's just a reliability gap here. There's no dispute that alcohol causes intoxication. There's no dispute to the expert's credentials of what his blood alcohol was. And there's no dispute, for purposes of this case, that he was drinking in one place between these times. Now,
But there is a dispute as to whether alcohol consumption causes obvious intoxication. That's the key. We can all agree he was intoxicated, but the question is whether it was apparent to the bartenders that he was obviously intoxicated, such that he was a clear danger to himself and others.
Yeah, and I believe, Your Honor, that when Ms. Hottie was asked if someone was in here and had 8 drinks, what would their behavior be, and she identified correctly all of the signs of obvious intoxication that would have been apparent.
But also the evidence doesn't indicate that that blood alcohol level was at that point when he left that restaurant.
Correct, Your Honor.
And to say that there's not evidence that it happened during that interim is not correct. There's evidence that he went to the restaurant, they ordered food to go, they had drinks, they went to this home, and then several hours later they left. You can surmise from that what happened during that interim.
And I'm not sure exactly where to direct this court for a citation, but there's a fair bit of common sense that we attribute to reasonable jurors. And if we're using the reasonable juror standard as to whether summary judgment is appropriate or not, again, we're not talking about medical causation here. We're asking jurors, all of whom are over the age of 18 and U.S. citizens, whether, and by the way, Your Honor, you stole my hypothetical, whether someone drinking 18 potential drinks in an hour and a half could lead to intoxication.
Could I ask a hypothetical? Sorry.
What does it mean for the person to be a clear danger, for the intoxication to be such that the person is a clear danger to himself or others? And I'm just thinking that in terms of driving versus not driving, right? There's certainly a level of intoxication at which you certainly should not drive, but you are otherwise not a clear danger to yourself or others. You can get in an Uber and go home, and you're not endangering anybody. Is the bar responsible for distinguishing between those two groups of people?
Well, I think there's 2 questions here. Could the bar potentially be responsible? Yes, and of course that would be based on the jury's determination of what they actually saw and what behaviors were exhibited and which witnesses they believe and which ones they don't. Again, I don't think we're drawing a bright line rule here today of was he intoxicated enough. We're simply asking on this record, if the blood alcohol content was 0.13 at 3 o'clock in the morning and he admits that he didn't drink anywhere else except at this restaurant in this hour and a half period, could a reasonable juror determine from those facts that he was likely exhibiting signs of intoxication that would be dangerous to himself or others? And I think the reason I keep going back to why it's important that Jennifer Hottie, the bartender, the TABC certified bartender, is qualified to make this assessment and why her testimony is so crucial is because this statute has a safe harbor provision. And the safe harbor provision allows the bar to escape liability if it can prove that it has required all of its employees to attend a TABC-regulated program about signs of intoxication. So in other words, if Jennifer Hottie's knowledge of what qualifies or what can get somebody to be that intoxicated and what signs they were demonstrating when they reached that level, her showing of that is enough to insulate the bar from liability, it would be nonsensical to say that that wouldn't be enough evidence to allow a plaintiff seeking damages from the bar to at least get past summary judgment. The law regards her as an expert in this field. And putting that aside, anybody who takes an application for a Texas learner's permit knows that you can't have 8 drinks in an hour at virtually any weight and not be intoxicated.
Could I ask you a hypothetical question to make sure that we're reading the statute in the same way? So suppose that when Khan came in, his BAC was 0.139. But as Hadi testified in the real world, he wasn't showing any signs of it, wasn't stumbling, wasn't slurring his speech, wasn't being loud or anything like that. If Khan's BAC had been 0.139 then, and she had served him 4 drinks, but he maintained that calm affect the entire time, would it matter that his BAC actually was 0.139 when he was in the bar? Or suppose she only served him 1 drink, and that put him to 0.147 or something.
Your Honor, based on, I mean, again, we're dealing with a summary judgment record here, so to say, what if all the facts were different, would that work is, I realize it's a hypothetical, but the whole point here is that bars don't test for BAC. They don't do horizontal gaze nystagmus tests. They know the amount of alcohol that they're serving someone, and they can observe their general
This
characteristics.
was supposed to be an easy hypothetical. We're looking for a genuine issue of material fact.
Correct.
And so I'm just trying to make sure that we're on the same page, that the fact that the BAC after he was at the bar or while he was at the bar isn't something that is going to put a third-party dram shop on the hook for damages. Is that correct?
Yes. I mean, it's similar to Justice Bland's question. We're not advocating for a strict liability standard based on a certain BAC.
Right.
We're talking about an extraordinarily high BAC 5 hours later that any reasonable person would allow someone to believe that this person was not in a normal state.
And so then we, understanding that the 0.139 that eventually came out of the blood draw, I think as you conceded is your best fact. Mm-hmm. What is your best fact that is contemporaneous with Cadeau's provision of the drinks at the restaurant?
The best fact would be the testimony from Ms. Hadi saying that anybody who was either at that BAC or had consumed 8 drinks in that amount of time would have been exhibiting signs of obvious intoxication.
And also Khan's statement.
Yes, that he was overserved and that he was intoxicated and that the bar should have acknowledged it. So
Even without that testimony, though, Khan's acknowledgement that he must have been overserved and the bartender's statement, even without that, I hear you essentially arguing that despite all the denials from Khan and the bartender and everybody else, the fact that it was 1.39 3 hours after the accident is circumstantial evidence that those denials are false. Is that your argument?
that is my argument. Yeah. But I don't think the court should put sort of a negative label on the word circumstantial, because remember,
right.
But again, you asked earlier if these were equal inferences, and we've all read City of Keller versus Wilson, and we know that circumstantial evidence that is simply meager evidence is not enough, to establish what you need to prove to satisfy your burden of proof. To say that a 0.139 retrograde extrapolation blood alcohol content at 5 hours after done drinking is meager circumstantial evidence would be like calling DNA evidence circumstantial evidence or a fingerprint circumstantial evidence. I mean, they are, it's not somebody that directly observed or what they heard or saw, but it's well accepted that it's circumstantial evidence that show that the circumstances in question would have had this person very drunk between 9 and 10 p.m. at Cadeau Restaurant. And so, although...
So the criminal proof is, I think, loss of, it's been a while, but of normal use of your faculties. That's a much different standard than, as Chief Justice Blacklock pointed out, the clear danger to himself or others. But I hear you, by using the blood alcohol content, equating the two. Where is that other indicia of proof that puts you more in the category of observed intoxication as opposed to intoxication that will result in criminal liability?
Well, let's say, in terms of what the statute defines of in danger of yourself or others, and contrast that with, or use that in light of Ms. Hadi's testimony of somebody at that level would be slurring their speech, not able to maintain balance, confused, dazed.
Right, so that's the expert opinion, but what's missing is linking it to that observed conduct, right? Because I think, isn't she also say he wasn't doing any of that to her? And I know we can disregard her statement is not credible. But then what are we left with?
If we're left with her acknowledgement that that's the type of behavior somebody would be exhibiting, this court, perhaps for the first time, will have to say, is that conduct that would show that someone's in danger to themselves or others? Inability to communicate or maintain balance could certainly lead to self-harm or harm than another person, regardless of how you got to or from the bar.
What if the person, it's going back sort of to my previous question, what if the person is clearly a danger if they drive, but otherwise not clearly a danger? And I have an easy time imagining that state of affairs. What's the duty of the bar?
The duty of the bar is to not serve, and there is obviously there's a interpretative element here. I don't want to say subjective, but danger of self or others, that's not a standard. The legislature could have gone with the blood alcohol content or number of drinks, as my friend said. But they put the burden on what is apparent to the provider, and they said clear danger of self or others. And given that that's not an objectively,
So the bar's got to assume that everybody there drinking is going to drive away and interpret clear danger to himself and others under that standard?
The bar doesn't necessarily have to assume anything for purposes of liability, for purposes of getting past summary judgment to show that there's at least a fact issue as to how that person was behaving, whether the people that were testifying that worked for the bar were lying or telling the truth. I see that I'm almost out of time. May I finish answering? I think, Your Honor, that's the most important part here, is that this is still at the summary judgment stage. So what behaviors a jury might ultimately find somebody was exhibiting, that will come back to this court perhaps another time in a legal sufficiency review when we see the evidence that came out, and that can be assessed. At the moment, the only question is, on this record, did they have enough to defeat summary judgment? I respectfully submit the answer is yes.
Are there any other questions?
I have one. On just to be clear, Khan's statement that he was overserved and that the bartender should have observed his intoxication at the restaurant, that's direct evidence, right? Not circumstantial evidence.
That would be direct evidence, Your Honor.
Thank you, Mr. Kidda.
Thank you, Your Honor.
Mr. Knight, I believe you have 5 minutes.
I know you got things you want to say, but it's my turn for a hypothetical.
Okay.
I sit up in my chambers, I drink a fifth of whiskey, and I am clearly overserved. And I leave, and I somehow get my truck out of the garage, but I pull up in front of the cloakroom right here, little bar, and I get out and I go in, obviously intoxicated. There's nobody in there but the bartender who's my buddy. And I say, give me a few more for the road, and he does, but he doesn't charge me, there's no tab, he serves me. Then I leave and hit somebody on the way home, but make it home without getting caught, hit and run, and 3 hours later they catch me. They track me down and run my BAC, and it's, 0.14. So the guy I hit, his expert says, I admit that I stopped at the cloakroom and had a drink on the way. But there's no record evidence, no tab. I deny that I was obviously, that it was apparent that I was intoxicated. The bartender certainly denies it. And I think what you're saying is in that circumstance, the injured party's simply out of luck because the evidence of the BAC cannot trump the testimonial evidence and the bar tab that we're relying on to deny everything.
So it's good that you led with that hypothetical because it was going to be my lead point. The facts that you just described, a situation of more likely than not service at a time when it was obvious to at a time when it was apparent to the provider that you were obviously intoxicated to the point of being a danger to yourself and others. There's a line of cases where that may be the case and the people at the bar are denying it. That was the case in the Davis case. And the way they got around that is by retaining an expert witness who testified, given all the facts and circumstances of your inebriation, your blood alcohol content, the timeline of what happened that night. There are cases, including the Davis case, where an expert is called to testify, taking into account your liquor tolerance, how the alcohol would have affected you, and placed you at a point in time when you were at that bar, plainly inebriated to the point of being a danger to yourself and others, and you were served. I think that might be.
But the only evidence of that is the blood alcohol content and then the additional expert evidence about my weight and tolerance.
The expert. In the Davis case, where everybody had denied that there was any obvious intoxication, and the evidence similar to our case here, from every eyewitness said, this person is exhibiting no signs. The plaintiff in that case retained an expert similar to what they did that only talked about things like blood alcohol content. And the Houston Court of Appeals acknowledged that, look, that's not the standard. What the Houston Court of Appeals says is an expert opinion about a person's blood alcohol concentration and the signs of intoxication a person would exhibit, when coupled with other evidence, can be circumstantial evidence of apparent intoxication. However, the expert must adduce evidence of conduct or signs of intoxication that the patron would have displayed to controvert the bar's evidence that he did not exhibit any signs of intoxication. So your hypothetical really brings us to the Davis case. And the Davis case is so similar to this case, where all objective evidence of how this person appeared is that he appeared perfectly normal at the restaurant, at the scene of the accident, where people trained to detect drunk drivers had no clue. And that's actually what Officer Williams said. I had no clue from his appearance that he was intoxicated. And it required the specialized HGN test to get him there. Now, their expert didn't go that far. He talks about things that are not the textual benchmarks of liability, blood alcohol content and the number of drinks that he surmises the man consumed, although he doesn't say they were provided by us. He recognizes that that's as far as their expert goes, so he's trying to rely on Hadi, a bartender, who testified that I worked there that night. Nothing happened that night. I am aware of the standards. I've never overserved somebody who exhibits these signs. And then she's asked a hypothetical question, well, but if somebody had, drank a lot, might they exhibit signs? Well, yeah, they might exhibit signs. But she's not an expert. She's not a toxicologist. She doesn't know Khan's tolerance to alcohol. This man may be able to drink quite a bit. And that's, real quick, the HDN test, Williams testified, is designed for those kind of people, because the pupils can't lie, but your tolerance to alcohol, you can hide your blood alcohol content through your behavior, but your pupils don't allow it.
Thank you, Mr. Knight. Your time has expired. Are there any further questions? Thank you, both sides. The court will take a brief recess.
Rise.